these truths to be self-evident.
That all men are created equal.
As a member of Congress, I get to have a lot of really interesting people in the office, experts on what they're talking about.
This is the podcast
for insights into the issues.
China, bioterrorism, Medicare for all, in-depth discussions.
Breaking it down into simple terms. We hold
these truths.
We hold these truths.
With Dan Crenshaw.
The Eagle has landed.
A couple of weeks ago, someone leaked a draft opinion authored by Justice Alito, which would overturn Roe v. Wade. Now, since then, the radical left has really kind of lost their mind because in his opinion, Justice Alito rationally lays out the reasons why the Constitution does not afford women the constitutional right to abortion. Now, this is obviously a very fraught topic, fraught with controversy. And I want to talk through the legalities of it. I want to talk through Justice Alito's opinion right now and understand the reasoning behind it. Of course, I think I need some help with that conversation, which is why we have with us Carrie Severino, who's going to walk us through this draft opinion, what it means for the future of abortion in America, and what she might expect from the court in the coming weeks. Carrie, thanks for being on.
Thanks so much. It's great to be here.
So I'll read a little bit about your bio. You're the president of Judicial Crisis Network, co-author with Molly Hemingway of the best-selling book, Justice on Trial, The Kavanaugh Confirmation and the Future of the Court. You speak on a wide variety of judicial issues, including the constitutional limits on government, federal nomination process, and state judicial selection. Testified before Congress many times. You were a clerk for Clarence Thomas, which I'm sure was an amazing experience. And I went to Harvard Law, Duke University, Michigan State University. Okay, so let's start at the beginning. If you could help us and frame in layman's terms the case that brought us to this moment, this draft decision.
Yeah, so this case came out of Mississippi, and it had to do with their law that effectively prohibited abortions past 15 weeks. Now, the vast majority actually of abortions happen before that period. And what was interesting about this law is while it's a law that actually comports with what most Americans, I mean, it is not more protective of human life than most Americans would want. So I think, well, Roe versus Wade basically throws the doors open to abortions for pretty much unlimited for 9 months. This law, if you look at what the actual average American wants, is most Americans actually do think abortion should be limited even after the first trimester, let alone 15 weeks, which is into the second trimester now. That's kind of the early end of the age. People might even be getting ultrasounds and sending around pictures of their baby. So the law actually fits in many ways what you might imagine would be an average result of the political process in America, and yet is clearly runs at odds with Roe versus Wade and Planned Parenthood versus Casey, which was the 1992 case that kind of upheld while rewriting Roe. And so when the court took this case up, I mean, it was naturally struck down by the Fifth Circuit, which said, look, we have to follow precedent, and the precedent says this law can't stand. But when the Supreme Court took it, it was not long after Justice Barrett had joined the court, and a lot of people realized, oh, wow, this is a real opportunity where now you have a majority of originalists in the court, and you might have an opportunity where the court would actually overturn Roe. And I think that is the direction the arguments clearly took in December, because as Roe versus Wade and whether this should be upheld is a very complicated issue politically. It's actually a very simple issue legally. If you are an originalist, if you think the Constitution should be read as it's written, the words should be read as they were meant at the time they were passed or ratified in the case of later amendments, then it's pretty open and shut. It doesn't provide a right to abortion anywhere in the text. And, while in 1973, the court decided to find one emanating from penumbras of a whole host of different amendments and didn't even commit exactly to which amendment it thought it came from, it kind of a good indicator that it maybe isn't in there in the first place. If you can't find a text that it even necessarily comes from, it's clearly not in the Constitution. So if you're an originalist, not a hard case, but we know the kind of pressure that the court gets. And so that's why people weren't sure, and we're still not sure, to be honest, even after this draft opinion, exactly how the court is going to rule with it. Are the originalists on the court going to actually have the courage of their convictions to say, hey, guys, I know this is going to be unpopular. It's going to be popular with a lot of Americans, actually, but unpopular with another big group of Americans. And this is the result mandated by the Constitution. Now you guys go figure it out in the states. Your elected representatives can work through this process themselves.
Was there something special about this Mississippi case or this Mississippi law in particular that was it drafted just right to make it up to the Supreme Court to tackle this very question of Roe v. Wade? Or was it simply because is this moment simply the product of the new makeup of the court?
I think a little of each. I mean, so there have been different strategies within the pro-life movement of what kinds of laws are best to bring challenges in these cases. And some of them are laws that you could argue are consistent in various ways with Roe and with Casey. So, we have laws about notification of the parents of a minor, or of being required to at least show the mother an ultrasound so she can make full informed consent, or anti-discrimination provisions that say you can't discriminate on and have an abortion because of race or sex or disability. So all of those kind of laws were one direction, and the court has considered some of those historically. But those are laws that were more kind of would chip away potentially at Roe, or would just say, hey, it doesn't. There at least are some limits on this kind of judge created right to abortion. Doesn't mean complete free for all. And then the other direction is the idea of, well, let's actually just put a law out there that is not consistent with Roe and see if the court is willing to acknowledge that Roe is bad precedent. And I think that's the direction Mississippi was going, because while you could kind of argue and say, I think the Chief Justice actually signaled that maybe he wants to find a way to effectively rewrite Roe and say, oh, there still is an abortion right in the Constitution, but it's not as expansive as it previously was, and it would admit a 15-week limit like this. That really would require judicial creativity, to say the least. It would require them to rewrite the law. So when this law was passed, what's so interesting is it was passed at a time when we didn't actually have a clear originalist majority on the court. This is before Justice Barrett joined the court. And so I think at the time it was passed, the best one could have probably reasonably hoped for, and if reporting is correct, the best they probably would have gotten would be something along the lines of what the Chief Justice is apparently writing in a concurrence in this case, which is something that would pare down and change the right in Roe, but not actually acknowledge that the Constitution doesn't say anything about abortion at all. And at that time, that would have been a big win. Like that would still would have been it would have been kind of legally unfounded to just make up a new right that's less expansive than the old right, but it would have been a step toward what the Constitution actually says. Mm-hmm. I think after Justice Barrett joined the court, suddenly it was like, oh wow, there's an even stronger opportunity here. And for that type of case, this is the perfect law, because the court doesn't like to go farther than it needs to in a case. If it had a case, say about the anti-discrimination provisions, which is something that was likely to come up, it already had been, I think there are petitions up to the court for, they could have taken that kind of case. That's one they could have said, hey, you know what? There's a lot of us who have real questions about this whole line of cases, but we can say at least it doesn't cover this case, and then carve out pieces like that. In the Mississippi case, there's no way to do that, because Roe very clear and combined with Casey very clearly would say you cannot have an all-out prohibition before viability. And while medical technology is incredible and it has moved the line for viability back from where it was in the 70s and even where it was in the 90s, for those cases, it is not 15 weeks. We're talking 21 weeks, with really good outcomes. With your best case scenario and technology and stuff. So 15 weeks is clearly before that. And so I think that's makes it a good case, because the court doesn't have an out. It can't say, well, we can do both. We can effectively split the baby here. We can not upset Roe, but we can find this law.
Bad metaphor.
It's maybe an apt metaphor. I don't know.
Okay. Well, I want to talk about Alito's decision and the and just the I don't want to make this a quiz on Alito's decision, but I want to go through the details of it for those who haven't read it. I think it's very readable to the non-law professor, but still, there's I think it would help us if you unpacked it a little bit for us. So he debunks three ways with the ways that the Constitution could, in theory, afford a right to an abortion. One is Roe v. Wade's reliance on the 14th Amendment and referencing the reference to liberty and the government's requirement not to infringe and protect a person's liberty. Of course, they don't really define liberty in a very explicit manner in the Constitution. They don't define a lot of words very explicitly in the Constitution. So we rely on history and precedent and the language of lawmakers at a given time. We rely on common law to come up with that definition. How does he address this particular argument about the 14th Amendment? Maybe describe to us what does the 14th Amendment do? It has a variety of clauses.
Yes. Yeah. So, the 14th Amendment, part of the challenge here, and he lays this out too, is that this is maybe their best guess for where this right is allegedly found in the Constitution. But even these cases you're trying to interpret themselves just say we feel that it's in the 14th Amendment, and so that that's not really great grounding. It's not saying, hey, well, this is clearly, if you're talking about free speech, let's look at the text of the First Amendment and what this involves. I'll read you some of the relevant text of the 14th Amendment, and it's saying that we have. Now I've got to find it in my. So no. First is all persons born and naturalized are citizens. So this is this is a post Civil War amendment. So this is making sure that former slaves are now considered citizens. And then no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall they deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. And there's a lot of other stuff in there, but that is the key part that they're trying to get this for. And you're right, the Constitution doesn't have a definition section where it says, well, this is what this word means, and this word means. And so it does that does pose a real challenge to people who are trying to interpret it. But there are ways we can look back and say, what did these things include at the time? And one of the ways we try to figure out what did the 14th Amendment cover is by looking at which rights were considered strongly rooted in American history and tradition at the time. So, for example, if you were trying to say that there was an inherent right to, I don't know, have internet access or something, well, that's clearly not something that was thought in the minds of people in 1865 who were ratifying this amendment, right? But the challenge here is the right to abortion is also one of those rights that when they passed this law, would they have thought, well, one of the liberties we're protecting here is the liberty of a woman to end the life of a child in her womb. That would never have been on the minds of these people. And we can tell this because at the time of the passage of the 14th Amendment, and Justice Alito goes into it and has a huge appendix, like a 30-page appendix, talking about some of the laws at that time, 3/4 of the states had laws effectively prohibiting abortion completely. And by the beginning of the 20th century, all the states did. And actually, I think it's only, he goes into, there's a lot of historical details to why they didn't all have them at the time. Originally, most states operated under the common law, which kind of had an understood corpus of crimes that were prohibited. And abortion would have been considered a crime and a criminal in unlawful behavior earlier as well. But then it was not till mid-19th century where they decided to codify these things. So it took a while for them to finish codifying all the things that had been previously recognized as unlawful before. But at that time, already 3/4 had said, no, this is not lawful. And then by the beginning of the 20th century, all of them had. So it's very clear. This isn't one of the things they thought, well, we're protecting this liberty because in fact, it was illegal in the vast majority of the states at the time. So you can't go back and just import what we think we'd like as liberties. We're certainly able to do that with the Constitution. The framers of the document knew this is not going to be perfect for all times. We're going to have to make changes. That's why we have Article 5 of the Constitution, which allows the amendment process. So we can amend it. So if most of Americans, as sometimes we're hearing from the left a lot, everyone wants this. Okay, great. Then we should have no problem passing a constitutional amendment saying that, that has effectively the same language as Roe, and it'll be no problem. I think the bottom line is that's kind of a very large oversimplification. I don't think if most Americans wanted it, you could pass it. And so when there is overwhelming public interest in something, you can pass a constitutional amendment and let's protect those things. But for the other things that there isn't a very strong, and they made it so you had to have really an overwhelming national consensus, because we're talking about a law, the Constitution overrides every other law, every other federal law, every other state law. you need to make sure everyone's on the same page before you make a clear constitutional statement like that, because that would take the rights away of the people. Until you get to that level, then the rest of these abilities are reserved to the people. So that means state legislatures, in certain circumstances, the federal legislature could actually legislate in this area. And then if you want your laws to look different, you address that to your elected representatives. You lobby for someone else to be elected, and this is how the political process is supposed to work.
And even to a non-law student, it would seem to me that yes, I mean, the Declaration of Independence states why government exists in the first place: to protect your life, liberty, and pursuit of happiness. So it's a very clear statement as to the purpose of government. It's a very unique one, actually, that we sort of created. Now, that doesn't mean I get to punch. That doesn't mean I'm free to punch you in the face. That's not what that means. Like, whoa, my choice. Don't mess with me. My choice. I want to punch that person in the face. You can't do that because you're infringing on their life, liberty, and pursuit of happiness. They cannot pursue their happiness if they're constantly getting punched in the face, or worse, you murder them. Right? So very clearly, we don't mean this expansionist sense of liberty. We mean ordered liberty. And I think they still try to make the case about ordered liberty as well, but it still gets to this point of, if you are infringing on the life of another, then it doesn't count as a protected right under this notion of liberty. Mm-hmm. And so then they try to say that, well, it's not really a life, it's a body part. And I think that's what has caused the utter lack of counter argument to that main point, that very basic point about the notion of liberty and infringement on rights. They skirt past it, and they've done this over the years by simply labeling it a fetus, labeling it as a non-living organism, labeling it as a body part, which is a separate conversation, frankly, not one I want to have here, because I really want to stick to the Alito's arguments. But I just wanted to make that point. What about the Fourth Amendment? So they also rely an incredible amount on this right to privacy that they say, which is also not a enumerated right in the Constitution, but they come up with it. So just tell us how that reasoning works.
Yeah. So the right to privacy is sort of this implied right, because there are certain rights in the Constitution that do touch on issues that you could broadly call privacy. So, for example, the right to not to be unreasonably searched or have things seized from you. Mm-hmm. Yeah, that you can say that touches on your privacy. The right not to have troops quartered in your home, that touches on your right to privacy. So, but what the move that happens here is they find several rights that actually are protected in the Constitution, and then they extrapolate from them to this higher or broader right of privacy, and then they pick some other areas that aren't actually in these constitutionally protected aspects of privacy, and they say, well, now those must be protected as well, because we have this overarching principle of privacy. So now we can, invent these other things, and that I think is the challenge here of saying, well, we've found this right to privacy, and therefore anything under that we can hang on that right must be covered. That's just simply not how constitutional analysis should work. And I think what the court does in this case is they don't go in so far as to say, that whole right to privacy idea is nonsense. But they say, hey, look, some of these other things that have been recognized within this area are very different types of rights. Because some of the other things, and this is where some of the fear mongering we're seeing is coming from, because there are some of those issues that have come up under this banner of privacy that the left now is saying, well, this case is going to overturn them. Like, for example, right, same-sex marriage, or the Eisenstadt and Griswold line of cases saying that states can't prohibit married couples or unmarried couples eventually from purchasing contraceptives. So those were held under this banner of privacy as well. And they're saying, well, if you're overturning one of these things that we've hung under it, you're necessarily going to overturn these others. It doesn't follow. And Justice Alito makes it really clear on a couple different places. This is not, none of those cases rested on Roe. So it's not like overturning that necessarily undercuts their foundation. On top of which, the type of right, privacy right that abortion was purported to be is very different from these others, because precisely as you mentioned before, this involves the ending of another life. So right, these other rights you're talking about are much more private affair, whereas again, if I can have a private argument between you, but that doesn't mean I get to privately punch you in the face. You can't use the words so expansively.
It goes back to this very simple notion of in private, are you also infringing on someone else's right? If you're marrying, if you're in an interracial marriage or a same-sex marriage or purchasing contraception, there is no way to see that you are infringing on someone else's rights, right? These are, you may not agree with these actions, and there's very few people in America that don't agree with them, but even if you don't agree, you cannot make the argument that this harms someone else.
Yeah, it's a very different type of thing. So I think that is a key to the analysis in this decision. And I think it's kind of telling that the leftist keeps on focusing on like, well, maybe it's going to do these things over here. Maybe it's going to do these things. Yeah. No, let's focus on what the decision actually does. Don't try to get a stump speech up on what you think it's going to do over here 10 years, 20 years, 50 years from now. What is this case? And let's talk about what the actual implications are. Yeah.
So Alito really leaves no stone unturned in making his arguments. So I want to go through some more of them. What is quickening, and why does Alito spend so much time on discussing quickening in his opinion?
So quickening is this notion of when a mother can first feel the movements of her child. And the reason it's relevant is because some of the historical arguments, one of the arguments coming from the left, partly because they knew we got a court full of originalists. If we want them to recognize this right, we're going to have to try to convey to them that, no, this was a right that was actually respected early in all of American history, not just from 1973 on or 1950, starting to bubble up, et cetera, on. And so they dealt with the fact that there were a lot of laws that criminalized abortion after the time of quickening. And I think what he points out is, first of all, it's very hard to tease out what that means, because it's not always necessarily just after you can feel a child, which is more often, it's a fuzzy line. It depends on the person. It depends. I mean, I've had 6 kids, and I think I felt them kick at various different stages, and all of them, it's not a fine line. I think in some senses, before some of the technology we have now, that was the earliest you could get confirmation that you really did have a pregnancy. And then he basically goes into the idea that even though it may not have been it may not in some places have been a crime before quickening, it still was unlawful. And there were various, evidences of that. Like if you were giving a woman drugs to procure an abortion, and then it turned out you inadvertently gave her a bad dose or whatever, and she died as well, that would be considered what we know as felony murder. So if you're committing like a bank robbery and you kill someone, you didn't mean to kill someone, but you ended up someone dying in the process. Yeah. You're guilty of murder, even though it wasn't a premeditated act to kill that person. It was a premeditated act to do the robbery. And so if you were premeditating a felony in the first place, then any inadvertent deaths that occur are on you as a criminal act. So you can see that they were already considered, even these pre-quickening abortion, as a unlawful act, because if you by mistake inadvertently killed the mother in the process, it was considered a felony murder. And that was one of the examples given in early texts. I think you can get into some very deep weeds. And as you said, Alito kind of covers all of those bases in detail in the opinion. The bottom line is clear, and that's that, even if it's not clear exactly which states were prohibiting what and to what degree something was criminal, it is beyond clear that in no place in America, or maybe in the world at that point, would it have been considered just a fundamental right to have an abortion. So even if doesn't happen to be illegal, we know there's a lot of things that might not happen to be illegal that are not like a fundamental right. If my state doesn't have anti-jaywalking laws, that doesn't mean I have like a constitutional right to jaywalk now. And that's the kind of thing. So this is where he's going with some of this historical discussion. Yeah,
I mean, progressives have a real bad habit of labeling something they just want as a right. You can want things, but it doesn't make them a right. And I think they use that because saying something is a right is a very powerful term. It brings us back to our own Constitution, our sense of history. And for rhetorical sake, it's a powerful term. What I would say too is the importance of the concept of life really revealed by this conversation about quickening, because feeling a baby is, especially as this term was used before the science could tell us whether our baby was even alive, So feeling the baby kick is an indication that it's alive, which is why they maybe separated it in that way, which of course leads to the obvious question of, okay, what is life? When does it begin? When is it deserving of our protection? When is it valued? And if it was going to start kicking in a week, but it hasn't started yet, well, you can kill it. Like it just has no value. Again, it's a bit of a more philosophical conversation, but it does bleed over into the legal questions, right?
Now, Justice Alito, I think, is careful not to take a major position on this. But it's funny. I mean, Justice Jackson may not be a biologist. I do have a degree in biology, but I don't think you need one to be able to recognize that fetal life is, in fact, if it's alive and it's human life. So that actually is not really, shouldn't be a legal question. It's actually is maybe a biological question, but it's not one that's complicated enough. You actually do need a degree.
If you find a multicell organism on Mars, we're going to say we found life on Mars, right? Right. Is it animal, vegetable, mineral? You can kind of narrow it down. So that does come into it. And I think while Justice Alito is very careful not to be making moral judgments here about the fact that, oh gosh, this woman's feeling a baby. And in point of fact, the baby's feeling it isn't when it starts kicking, even it's the baby's kicking. It's just sometimes so small that you can't feel it until, a lot of mothers will have the experience of seeing an ultrasound. You see the baby moving, you can't feel that movement because it's just too small, or there's too many layers of muscle and fat and everything in between. So it's a rough proxy at best for what's really going on there. I think what is great about this opinion, though, is the Roe and Casey line of precedents. They didn't claim they knew that this wasn't life. They said that we can't really, that's above our pay grade. But the very fact that this is a debate about when is life worth protecting, and it touches on those fundamental things, is kind of an indicator that this is maybe something, if the court doesn't really know if it's life or not, maybe you shouldn't be the ones making the judgment call here about when it's okay to end I mean, if it's not alive, I don't know what it means to end a non-life, but to effectively end the child's life in the womb. So Roe and Casey kind of say they're not making a conclusion, but in their analysis, they really are, because if you acknowledge that this actually is even a potential human life, I think you have to recognize, just as I think the analogy that many people use, just as shooting into a building and not knowing if people are there could be easily, and you happen to kill someone, could be deemed reckless manslaughter, because you shouldn't be shooting if you think there might be someone there, right? So I think that shows the court was pretending it before it was staying out of it, but not really. I'm not sure if I'm saying this term right. Stare decisis.
Mm-hmm.
Did I say it right?
Right. You got
Why do all legal terms sound like Harry Potter spells?
They're all Latin. That's why.
All right, but why is this particular legal term important in this case?
Yeah. So Alito's opinion really has two halves, and we've been talking up till now about the first half, which is are Roe and Casey actually properly decided? Is there really a right in the Constitution to have an abortion at all, and to what extent, or whatever? Is that there? And then if the answer to that question is yes, then of course you would uphold it. Mm-hmm. But the answer to that question, as Justice Alito clearly says, is no.
Yeah.
But then you have the secondary question. Okay. And judges deal with this on a somewhat regular basis, but not always with as significant a precedent as this. You've got a case before you. You're like, you know what? That case is not correctly decided. Do I follow that case? The lower courts are bound to follow the case, no matter how egregiously wrong it is, right? If you're an appellate judge, if you're a district court judge, you have to follow it. If you're a Supreme Court justice, you have a third option, which is we could reconsider that case and say, you know what, that case is really wrongly decided. We're not going to follow it. In certain circumstances, you might say, you know what, I would have gone a different way in that case, but we're gonna keep following it. And the court has traditional features it looks at to make that decision, and they really make sense when you think about them. One is kind of how wrong is it? Mm-hmm. Is this case it's egregiously wrong, and so just out to lunch? It's at odds with the Constitution completely. Or is this a case that was like, you know what, as that was a close call. I definitely would have gone the other way, but you know what, we'll go with this one. So if it's a close case, the court is much more likely to say, let's just follow that case, right? There's also the question of how well does this fit in with the rest of American law? Is this a case that if we decided this way, it's going to create a lot of other disjunctures within the law. It's going to be inconsistent with a lot of other areas that we have laws. And so maybe this isn't going to fit well within our legal system. Or is this a case that, everything else is going to still work properly, even if we carry on with this admittedly wrong result? And so as we can see by the first discussion, he definitely concluded Roe was egregiously wrong, definitely nowhere in the Constitution. On this second point, there are a lot of areas that in which it doesn't fit well with the rest of American law, and in which we've seen what some have termed the abortion distortion. So in order to try to protect this right recognized in Roe, other aspects of the law have been kind of stretched, morphed, played with, everything from standing law, who gets to sue in a case, to First Amendment law, which has been kind of, this kind of sui generis special rules for if you're protesting in front of an abortion clinic, you might have fewer First Amendment rights than you do other places. So a lot of areas of law have had to kind of stretch and bend to make space for this right. So that kind of may be an indicator this isn't one that you should follow. Reliance interest. So if, say, you had like a tax law and it was tax statutes interpreted one way, and all of these businesses have like structured everything, for this tax year, or maybe going back several, based on this incorrect interpretation. If you change it, it's going to have huge problems and throw all that stuff off. Maybe that would be a reason to consider, like, what, everyone's already calculated this in. I know that wasn't the way, like we started out playing with the wrong rules of monopoly, but we got to finish the game this way because we're already too far, that kind of thing. So if you have serious reliance interests, the court's more likely to leave it. And
is that why they keep making these disingenuous arguments about interracial marriage being overturned, same-sex marriage being overturned, contraception rights being overturned?
Well, those are some of the reasons those rights are unlikely to be overturned. I mean, none of these is an absolute, because think about, for example, and this is an example this opinion gives, Brown versus Board of Education. That is a case that overturned a previous Supreme Court decision called Plessy versus Ferguson that said separate but equal is A-OK under the Constitution. That decision was wrong, clearly wrong, but for decades, America was operating under an idea that you can have laws that create segregation and separate facilities for Black and white people, and that was okay, right? So there was a whole lot of reliance on that. I mean, look at the South had separate schools, separate, train cars, separate bathrooms, separate water fountains, all of these things built up on that. So you can have a system that has a lot of reliance built up and still say this is so egregiously wrong that we have to correct it. So again, none of these is perfect. I think, or is a if you check the box on this,
there's no silver bullet. I was just more curious because as they're so desperate to make these arguments, that maybe is that why they've gone to these desperate attempts to say, look, it's reliant on these other rights that we all agree on are reliant on this one, so you can't overturn it, so you've got to maintain precedent.
Yeah, I think in truth they can't make so none of those cases that they're talking about. Some of them are.
We already, you and I already kind of debunked those.
Yeah, before Roe. So like clearly they're not. The Loving versus Virginia, the anti-miscegenation case. That's the one that makes me most annoyed. Like, A, no state in the union would ever consider undoing that, and B, there actually is a fundamental understanding of marriage that goes back not just to the beginning of this country, but thousands of years that would have recognized that interracial marriages are actually true marriages. So you just can't throw them in the same bucket.
Right.
And crazy. The idea that Justice Thomas, who himself is in an interracial marriage, is just raring to go. Let's get rid of Loving.
Right.
That's ludicrous.
Right. Isn't that crazy? Amy Covey Barrett is interracial family.
Oh, I know. She's got multiracial kids, and she's gonna. It's such a silly statement. Someone even was tweeting the next thing they're gonna do is overturn the women's right to vote, and I was like, newsflash, guys, that's literally in the Constitution. So I don't think a single justice in the court or anyone in the country wants to say, here's text of the Constitution, but we're just going to take that away because we're mean, angry conservatives. Come on, folks. Let's do some, rational arguments and not just ad hominems. But at the end of the day, so Justice Alito considers all of these factors, and really on every single one of them, Roe fails. So we were talking a little bit about the reliance interests. Yeah, it's some on the left, they'll say women have built up their whole lives with the understanding that abortion is an option for them. And I think there were a lot of really powerful amicus briefs from women saying, first of all, I don't think it ever had to be a complete choice of you can't have a career if you are going to have a family. But obviously it was things were different in the 70s than they are now, both for women being able to work in general, but also the idea that a woman could have a pregnancy if they were single and then somehow be able to carry on in society. And Justice Barrett, as she pointed out in December, also there are so many more options for adoption and the ability of women to say, hey, there's a safe harbor thing. So if you realize I am not capable of caring for this child, you can drop them off, no questions asked, and we'll make sure we find a loving family for them. And she's saying this as an adoptive mother herself. So she really speaks for experience. I think though all of those things point out that it's not fair to say that this is the kind of thing that somehow, an entire legal structure is going to change. I think it's interesting because we're seeing a lot of states really beefing up their social safety net for women who then are finding themselves in these positions. And that is another area that's changed dramatically since 1973 as well. The network of crisis pregnancy centers and mothers' homes across the country who are really trying to make sure that this is about helping the woman, not just for these 9 months, but then get on solid footing so that whatever her choice is next, whether she chooses adoption or chooses to raise the child, that she has the resources and the help and the mentoring she needs to be able to do that.
One of the final things Alito addresses is the questioning of political decision-making in this case. And why is that so significant to this ruling?
Well, you're hearing it in some of the rhetoric around this opinion too. The idea that, well, this is a politicized court and these justices, because the conservative justices happen to be the one, and frankly, not all of the Republican nominees are, according to reports, signing on to this opinion. So it's not necessarily a party line kind of thing, that somehow that makes this a political court. And I have a lot of problems with that. First of all, no one's complaining that 100% of the Democrat nominees are voting the same way on this issue. So like if sauce is good for the goose, good for the gander on that front. But it's also suggesting that having any time that your result happens to line up with whatever party nominated you, that must be because of the party affiliation. And I think that's really insulting to what the justices are trying to do here. If you look at the scope of all of the types of cases they look at, there are a lot of cases in which you see these justices coming and for originalist reasons too, when they're citing these original, coming to conclusions that might be at odds with what they would feel politically. Take the First Amendment protecting flag burning, for example. That's something that was outrageous to probably every single one of the justices, but yet they recognized is protected by the First Amendment of the Constitution. And so a lot of criminal protections, Justice Alito and Justice Scalia, the leading originalists in the court, actually led the way for a lot of expansion of defendants' rights because that is in the Constitution. So it's something you wouldn't say is, oh, this is a conservative type of thing, but it's not about being politically conservative. It's about being constitutionally conservative, sticking with what the Constitution says. So I would say if you think they're making the judgment call on political matters, then critique their reasoning. If their reasoning is sound, then I don't think you can say they're doing it for political reasons. I think it's clearly for legal conclusions.
And speaking of legal reasoning, how do you anticipate the liberal justices arguing against this? What will their dissent sound like?
Well, it's interesting. We don't really know, obviously, but from looking at the December arguments, I thought, and even looking at some of the arguments that we're seeing out there around this, I think most of them are focused not on trying to defend Roe itself, saying, oh no, the 14th Amendment clearly did encompass the right to abortion. Here's why. They're focused on the stare decisis point. They're trying to point, I've been just amused watching some of the people playing clips from these various justices' confirmation hearings saying, well, they went back on their word to uphold this case. If you listen to the clips, it's ludicrous because they're all saying things like Roe versus Wade is a precedent of the United States Supreme Court. It was decided in 1973. Like nowhere does anyone say, and I will uphold it. They'll say it's important. They'll say it's been upheld before, but no one said that because they know they can't. They can't say that about Roe. They can't say that about Brown versus Board of Education. They can't say that about their favorite case, their least favorite case, because they can't promise how they're going to vote. So the focus, I suspect, is going to be more on the stare decisis point, saying, hey, you guys need to uphold and follow this case. It's somehow illegitimate to overturn a case. That, I think, though, is the weakness in that argument, and Alito addresses it to some extent, is the fact that every justice in the Supreme Court has overturned cases. It's not, no one thinks you have to follow every case out there. And Alito has a footnote that is over a page long of very small font with just listing cases where the court has overturned prior precedent. It happens. It doesn't happen every day, but it does happen with regularity. And it's an important part of the court's role to make sure that our law stays in keeping with what the Constitution demands.
How long do you think Alito's been sitting on this particular argument? Like, it's probably not the first time he's thought about it.
Well, I mean, one of the things about being a judge is it's not like a legislator where you can say, oh, I've got this agenda that I really want to, I'd love to make some law in this area. And you guys can just sit down and write a law. And if you can find sponsors and get it voted on, you can do it. A judge has to take the cases that come to them. I mean, the Supreme Court has a little more flexibility than many places because they can turn down cases, and they do turn down the vast majority of the cases that come to them, but you still can't invent a case out of whole cloth. So, it's not like he could say, oh, I want to write a case on this and let's see if we can get my colleagues to accept one. It really, I'm sure this is something that he that had, because the court has taken cases that touched on this issue. So it's something he's thought about for a while, but I think it's the kind of thing that until that case really comes before them, it's hard to, I don't think he had a draft sitting in his closet, for example. I think this is something that you write this opinion based on the case before it and based on the filing. So a lot of what he's writing is explicitly responding to some of the arguments brought either by the litigants in the case or by the dozens of amici, the amicus curiae, the friends of the court brief written by all sorts of different law professors and members of Congress and special interest groups, et cetera.
Well, what does the leak mean exactly? Does it mean that they had this this sort of informal vote behind closed doors? Why did Alito write the opinion? How does the Supreme Court work? Yeah.
So what would have happened is they sit for 2 weeks every month. And this is from the December sitting. So it started the very last week of November and the first week of December. This one was argued the first week of December. They will meet the same week, either on Wednesday or Friday, to vote on the case. So they heard the oral arguments in this case. I think they heard them on Wednesday, if I recall correctly. And then they would have voted on Friday. And so by Friday, all the members of the court would have known what the outcome, at least provisionally, was. And the vast majority of the time, those votes end up being the final layout. So they have a special conference room off the chief's chambers, and they all sit around the table and they go in seniority order and say, here's what I thought. I think it should be said this way for this reason. And then after everyone talks, they can see, okay, there's 5 votes for this. And what it seems like in this case is there were 5 votes for something along the lines of what Justice Alito wrote. Mm-hmm. There were 3 votes saying, no, Roe and Casey are great law. They should stand. This law should be struck down. And then there was the Chief Justice who, when this is a lot along the lines of the questions he was asking oral argument too. So the reporting didn't surprise me on this. He apparently is going to try to write a decision that upholds the Mississippi law, but then, comes up with some new standard, which allows a 15-week law, but not, but says that Roe and Casey aren't overruled.
So will that be considered a dissenting opinion? Is he a no vote? How does that
it would be considered a concurrence, because the end result, if he writes that opinion, the end result is the Mississippi law does not get struck down. So there are 6 votes on this reporting that say the law stands, and there are 3 votes that says it's struck down. So if they're coming to the opposite result on that final question, they're a dissent. Okay. He would be what we call a concurrence in the judgment. A concurrence is something where a judge comes to the same conclusion. Sometimes they're concurring, which means they sign the main opinion, they agree with that, but maybe they want to add a different angle, or they want to say something more in their own side thing. A concurrence in the judgment is what it sounds like the chief was working on, which means we come to the same result, but by a very different path. So they're not going to overlap in reasoning. The one who gets to decide who writes an opinion is the senior justice that is in that majority. And in this case, because the chief wouldn't actually be signing that majority, he's ex officio. He's always, if he's in the majority, he gets to decide. So he does get to assign the vast majority of cases because he's always going to be in the majority as chief. But after Roberts, Justice Thomas, who is actually the justice who served longest on the Supreme Court, he's going to be senior. So because he was in that 5-justice majority, it seems that Justice Thomas would have been the one to assign it to Justice Alito, which in and of itself, I think, is really interesting because, boy, this is like the opinion of the term, right? Some justices would have been like, oh, I'm taking that one. That one is going to be under my name. This is my legacy. And that's not the way that Justice Thomas works. I think he probably would have thought, okay, who's the one? And after they've all heard each other discuss it, they know how each person would write it and how, something about their approach to it. And I think he clearly made the judgment call that Justice Alito is the one who is going to do a great job on this and will be able to write an opinion that commands a majority. Because you also don't want to pick someone who might write an opinion that's going to have a quirkier view or that might not be able to maintain those 5 votes. Because sometimes the justices could read it and be like, that doesn't work for me.
I wasn't quite there. Yeah.
Yeah. You want to be able to. So that shows both, I think, Justice Thomas's grace in leadership, but also his real confidence in Justice Alito to handle this major piece of work. So then it seems like this was the first draft that's stamped on it. That would have then circulated the beginning of February. So he would have been drafting it through December and January, goes through a whole lot of editing in chambers. And then, so this is not, first draft doesn't mean like I just scribbled this off yesterday. That would have been heavily worked on within the chambers. And only then would you circulate it to the justices. So then it goes to all 9 justices, even the ones in the dissent. Everyone gets to read it. And then what normally is happening, and again, there's kind of, the reporting on this is that no other opinions have circulated, but what would normally happen is everyone reads it. And then the people who are writing the dissent could be one of those 3 judges, could be all of them want to write their own dissent. They might join each other's dissents. It's kind of whatever you want to do. They might circulate their dissents and say, hey, thanks for your opinion. Here's my dissent. And so both sides get to see it. You might have the majority adding some things saying, well, Justice so-and-so's dissent says this, but here's why I responded to their criticism. Here's why they're wrong. And so you do normally have some edits that happen that way. You could have the other justices in the majority saying, hey, I like this. Can you, section 2B, can you take that part out? Or can you add a reference to this? Or,
Sure.
Some people get really picky. We had some justices who'd be like, I think this comma actually should be here instead of there.
Yeah.
But for the most part, the justices are really just looking at content. Or at least when I was clerking, it's been a few years now, they're looking at the content, making sure I have to make sure I agree with 100% of this. Or every once in a while, I'll have them saying, I'm going to sign your whole opinion except for footnote 3. So footnote 3 might not have the force of law, but the rest of it does. So
Interesting. Okay.
That's the kind of discussions that would have been happening behind the scenes.
Okay. So then even if Justice Roberts, because he's the 6th vote, so they don't need his vote, but so he can do his concurrent opinion, still uphold that law. But because 5, which is a majority, would all sign Alito's opinion, that would, in theory, become law and become precedent.
Right.
What do you think of the leaker? I mean, who's the leaker? Some people think it's a conservative. I'm not really sure. I don't really think. I'm not sure what the intent would be, the motivation would be. How does something like this happen? Is this unprecedented?
It really is unprecedented. I mean, the idea that you have it's not 100% unprecedented to have leaks in the Supreme Court, but you know how leaky Congress can be. Like this is kind of par for the course if something gets leaked from the legislative branch or from the White House. Same thing. Like this is kind of how Washington, D.C. journalism works. And sometimes people are leaking their own stuff on purpose for various reasons, right? That is not how the Supreme Court has ever worked. This is not a leaky institution. Until this May, we would have said this is the one institution in DC that doesn't leak. But that's not really true. So there have been a handful of cases where in Roe versus Wade itself, for example, there apparently was a leak to Time magazine where they knew like the day before the opinion that it was going to come out. And I think they might've known the vote. But it was considered outrageous. And Justice Berger was going around trying to figure out who the leaker was. And he was outraged at that. So that level of leak is where it's like right before the opinion comes out and all you know is the outcome. Was the kind of the closest parallel to what we have of any historical type of thing. Now we have 98 pages of an opinion just straight out there, and then months ahead of when it would have come out because everyone expected it the last week of June. We still don't know when it's going to come out, but probably toward the end of June. And so this is significantly early, and it looks like the rationale was we want to affect the outcome of the case. So we're trying to put pressure on the justices to change their votes. I suspect, as many people, including people on the left, just immediately jump to the conclusion, it's got to be a liberal clerk who wants to try to basically get the court in trouble for this, what they would have considered an outrageous decision. And in the hopes that maybe that'll be enough outrage to peel off one or more of those 5 justices from that opinion and make them maybe want to join the chief's concurrence in the judgment, maybe, I don't know, join the dissent. I'm not sure. If that was, I think that still is the predominant assumption, right? I think that it probably will have been a miscalculation, but remember, we're talking about 20 somethings who this is one of their first couple jobs out of law school. So this is not like a sophisticated political dealer, probably, although sophisticated enough to know what, who to leak to at Politico. But I think it was a miscalculation if that was the goal, because I think we've seen now a backlash, the amount of protests, especially this protesting at people's houses, which if you look at it, even most Democrats think this is beyond the pale. Don't do that. Yeah. This is not where we should go. And so this level of outrage is actually, I think, backfiring on the left. Some people would on the left, I mostly are saying, oh no, it's definitely a conservative because they wanted to lock down the votes. They wanted to say, justices shouldn't switch their votes because everyone will know you switched and that will look bad. I think it's true. It would look bad. And this makes it clearer that if you had switched it, but the reporting is that no one had switched their vote. Yeah. So I think that plus, I just, maybe I'm biased. I don't think that's how the conservative clerks work. I think a liberal clerk, if after this is done, if you did this 50 years ago and you were discovered to be a leaker from the Supreme Court, you would have been out of the legal profession altogether. No one would want to do business with you. I worry that today our standards have changed, the standards of professionalism. And I think some people were going to hail this person they already have as a hero and a martyr for the cause.
Absolutely.
And so
they might be disbarred, but that's about it.
Yeah, that person's not gonna lose their job going forward. They might actually get a New York Times best-selling book out of it. They might become an MSNBC contributor. They might get a chair at a law school. Who knows? If it's someone on the right, none of that holds. MSNBC is not going to hire you as a commentator, and I don't think people are going to be praising someone who did it.
No, I mean the pro-life community would be upset about it. I don't think anybody likes it.
Everyone that has spoken out in the court, I have not heard any liberal justices making public statements about it, but like Justice Thomas recently talked about how horrible this was for an institution. I think this is something that would be really not endear yourself to the legal community.
This has all been really enlightening and good for the audience to understand if you care about the actual arguments being made here from a legal perspective. We've done plenty of episodes, I think, on the moral arguments, the philosophical arguments. There's a lot of ways to argue for this cause, but it's also important for people to know, by the way, that because a lot of people misunderstand this, that Roe v. Wade being overturned does not make abortion illegal. I think the large number of people that are believe that will soon be corrected, because if it is overturned, but necessarily you will come to the conclusion eventually that it's still not illegal, depending on what state you're in. So, this will be interesting to see how this plays out. I wanted to actually ask you some bonus round questions, some things that are completely unrelated, but I mean, not unrelated to law or the Supreme Court, but questions that I struggle with. I wasn't really prepared here, so I can't remember the case that I want to ask you about, but I'm sure you'll be able to remember it for me. Because it drove conservatives a little crazy. It was Gorsuch's opinion, basing it on this textualist argument, and the case was regarding the funeral home worker who had identified as a man for years, worked in this place, and then all of a sudden I started identifying as a woman. They fired him for that, and they sued. And in that case, he won that case, or she won that case, whatever. What concerns me about this entire issue, in Gorsuch's opinion, is are we moving into an era where the right of association is taken away from us? Now, the counter argument to what I just said is, well, look at the 50s, look at the 60s, when that right to association meant segregation, which was clearly wrong. I'm not sure we're having the same conversation here in this case, especially. And here's why, and here's my argument, my legal argument, because in one case, we're talking about immutable characteristics, skin color. In another case, we're talking about behavioral changes. If your behavior changes radically, don't I have a right not to associate with you anymore based on your behaviors? This decision really upends that what I think is a right, my right to association based on your behavior around me. What do you think about everything I just said there?
So, the real fundamental question that, I mean, you could talk about the right of association pushing back on this, but what the case was interpreting, I think it's wrong at a much more basic level. It's the Bostock versus Clayton County case that you're talking about. That's what
it was. Yep.
Yep. And
I knew you would know it.
Yep. That's
like, it's like you do this. Right. It's like you do this for a living.
I know. It's almost like I'm a lawyer or something. So that case had to do with the interpretation of discrimination because of sex. And so it really is just a basic definitional question. What does it mean to discriminate be discriminated against because of sex? And this kind of goes to some of the same questions we were talking about with respect to how do you interpret, what liberty means, what all these things mean. You can interpret that in a lot of different ways. What did the people who actually passed that law mean? What did that mean to them when you said, what does discrimination on the basis of sex mean? Because there were actually even two issues going on in those cases. It was having to do with discrimination on the basis of same-sex attraction, because there were a couple of people said who they'd been fired because they were gay, not because it was a man, because he was gay. And then the funeral home worker that you were talking about, that was because of them being, and I think the case actually specifically says transgender. So it's not, they don't use the broader term of gender identity, just wanting to switch from one gender to more of a, it's still recognized as a binary, the way that Justice Gorsuch wrote that case. But the question is, do those type of discrimination, even if we don't really, not in neither case actually, is it clear or determined whether they even were discriminated on the basis of that basis, right? So is this guy really fired because he was gay? They didn't get to the point of even discussing that. It was like, could you even make the argument that if he had been fired because of that, it's illegal? And what the court ultimately said was, even though at the time it was, I think, abundantly clear that discrimination because of sex meant discrimination because you are a man or because you are a woman. What Justice Gorsuch did is he did a much more like, I would say, just hypertextualist in a view of it, and saying, well, the word sex can mean these other things. Like sex could imply sort of sexual orientation, because it could be a broader term. So maybe because of sex could mean something much more than that. And there was an argument that Justice Kagan advanced that he found attractive, that said, well, if someone is being fired because they are transgender, it's because of sex, because if they brought their partner to, say, a party and it's a woman and she brings a man, she's not going to be in trouble. And if she brings another woman, she is going to be in trouble. So they say, well, in that case, it is because of sex. It's because of the nature of the sex of the person that they are attracted to. The argument that Justice Alito actually made in contrast to that was, it's actually not. They don't care if it's a woman with a woman or a man with a man. They just care about, is this person same-sex attraction or opposite sex attracted? And it's not because of sex, because it could be, any more than saying like if it doesn't matter if it's male or female, I guess is the bottom line. It has to do with a different thing. And you could see from the history that right around the same time that this law was passed, there were people saying, we need to add sexual identity to this. And it got voted down. And then regularly over the next few decades, people were saying, actually, let's add sexual identity as another thing you can't discriminate on. And it would not pass. So at the time, all the Congresses that considered it recognized. And then ultimately later on, saying that we're making some of the same analysis with gender identity, which wasn't even on the map in 1965 when this, right. I mean, not in a serious enough way to be considered as a discrimination grounds. They knew there was a difference. There's one thing called discrimination on the basis of sex, and there's another thing called discrimination on the basis of sexual orientation. And there's another thing, I would say, the discrimination on the basis of transgenderism. And they're all different things. If you said it was so broad as say anything having to do with sex, then you'd say, well, this guy sexually harassed his colleague, and so I'm going to fire him. Well, that's discrimination on the basis of sex, because it has to do with sex that he got fired. That's clearly not what it meant. No one has thought that's what it meant, even though if you took this, again, insanely dictionary definition basis, you could be like, oh, he got fired because he slept with his coworker. He got fired because of sex. Well, yes, but that's not what this law means. And so you have to go and look at, see what do these words mean, and what did they mean to the men and women that actually passed them? Or at the time, I guess we don't have to do psychology and figure out what was in their heads, but what did that mean in 1965 when it was passed? And there's a lot of evidence. Yeah. You can say that's not what it meant. So Gorsuch, I think, got caught in a trap of, like using the dictionary as his right. key
got
to
too
this.
Clever,
you have
too
to
clever
know,
for his own good.
Too clever by half.
And it's also strange to me because it's not as if you don't already discriminate on the basis of sex for a variety of jobs. This has changed now, but for decades and decades, the SEAL teams do not allow women to even try out. Mm-hmm. There's a nightclub only hires attractive women to be their servers. So clearly we're allowed to discriminate on the basis of sex. I'm not sure what the difference is between that and these others. And my question would be, if you're an employer and you have a man that works for you, and he's worked for you for years, and he comes in the next day dressed in a mini skirt and high heels, his behavior has changed radically, but now because of this ruling, you cannot fire him. They could sue you for that. Is that
Well,
true?
and that's effectively kind of what happened in the funeral home case. Because what he was saying is I fired this guy because he violated the dress code. Because
Right.
and you imagine like if you do have to have a clear dress code because someone's showing up at a funeral, you don't want him showing up in some kind of crazy outfit that's going to just distract from the really solemn occasion that's there. So you have to wear a suit, you have to, or you have to wear a skirt if you're a woman. But there's a clear dress code, and so the question is, can he continue to hold this employee to the male dress code, which again, he'd been employed there for many years. So, it was following the male dress code, then changed, was following the female dress code.
Right.
Can you have those dress codes? And, the distinction you point to, I'm kind of glad I was helping my husband with his civil rights law class that he's been teaching this semester and helping on that, because it's at least refreshed my memory on some of these things. There's a difference between like racial discrimination, sex discrimination, because as you point out, there are jobs for which sex actually is a difference. Like really the difference between races is in fact skin deep, right? So you can't discriminate based on race for these jobs,
right.
But there are jobs that might not, where you might need to have a woman or a man. Imagine you're having hiring someone to be a counselor at a battered women's shelter. It's going to be a big difference whether these women are going to be comfortable talking to a woman or a man. This is a bona fide occupational qualification, as we like to say. So there are real distinctions there. And historically, and even Justice Ginsburg acknowledged, you could have like a different dress code for your female employees or your male employees or different things like that, as long as they were related to those differences. So there's always been a different standard for how we look at discrimination on the basis of sex, where there are two differences, and it's held to a slightly different standard than like discrimination on the basis of race, which is virtually never allowed.
Right. Well, I probably have many more bonus round questions, but we've kept you long enough. So this has been fascinating, and really appreciate, Carrie, you lending us your expertise.
Thanks. It's been so great to be here.
Great.